Divorce doesn't just divide assets, it directly affects your estate plan. If you don't update your plan, you may unintentionally be leaving assets to your ex-spouse or create legal disputes that drag your family through unnecessary conflict and expense. In this video, I'll walk you through what happens to your estate plan during divorce, what you can and can't change while the process is ongoing, and the key steps you need to take once the divorce is final to make sure your wishes are actually carried out. In California, the moment a divorce is filed, automatic temporary restraining orders, known affectionately as ATROs, go into effect. These orders aren't optional. They apply to both spouses right away, and they'll stay in place until the divorce is finalized. So what do ATROs actually do? Well, they put guardrails in place. Neither spouse can make big changes to joint property, beneficiary designations, or the estate plan during the divorce. The purpose is simple: to protect one spouse from disinheriting the other, draining accounts, or shifting assets while emotions are high and the process is ongoing. For example, without ATROs, one spouse might attempt to move property into a trust that doesn't include the other, or change the beneficiary designations of retirement accounts overnight. The law recognizes how unfair and disruptive that would be, so ATROs freeze the situation. Now, this doesn't mean that you're completely stuck. There are still some changes that you can make during a divorce. The key is knowing which changes you can make freely, which changes require notice to your spouse, and which changes require court approval. Here's what you can do without notice to your spouse. You can create, modify, or revoke a will. You can update your financial power of attorney or healthcare directive. And you can create a brand new trust. You just can't fund it until the process is over. Here's what you can do with written notice to your spouse. You can revoke an existing revocable trust. You can change beneficiary designations on pay-on-death accounts, life insurance, or retirement accounts. And you can eliminate the right of survivorship for jointly owned property, like joint tenancy or community property assets. And finally, here's what requires court approval: transferring, encumbering, or disposing of property beyond normal living expenses, making any changes that will affect how community property is ultimately divided. The bottom line is you're not powerless, but you must follow the rules. Otherwise, you risk violating court orders and complicating your case. Once your divorce is finalized, some changes to your estate planning will happen automatically under California law. First, your ex-spouse is treated as having already passed away for purposes of your will or your trust. This means that if your will or trust left them property, these provisions are automatically revoked. It's as if they're no longer in the picture. That is, unless you intentionally put them back by creating new documents after the divorce. Second, any powers of attorney or healthcare directives naming your spouse are automatically revoked. They can no longer make financial or healthcare decisions for you by default. If you still want them in those roles, you'll need to sign new documents after the divorce. These rules are designed to help people who forget to update their plan, but they're far from perfect. Here's the important part: federal law does not always follow California law. For example, retirement plans governed by ERISA, which is most of our 401ks, will still pay benefits to whoever is listed on the beneficiary designation form, even if that person is your ex-spouse. California's automatic rules will not override this. So if you don't update your beneficiary designation forms after your divorce, your ex could still inherit those funds no matter what your will or your trust says This is why it's so critical to take a look at every piece of your estate plan after divorce, because some updates will happen for you and some are your responsibility. While some things change automatically after divorce, there are just as many things that will not change and will require your action. Beneficiary designations won't change on their own. Retirement accounts, life insurance accounts, pay on death accounts will go to whomever is named on the beneficiary designation form. If that's your ex-spouse, they will inherit those assets, regardless of what your divorce decree or your will or trust say, unless you update those designations yourself. Guardianship nominations for children also remain unaffected. If you pass away, your ex still has parental priority as the surviving parent. This is true even if you've named someone else in your will. While you can plan for contingencies, like what happens if both of you are gone, divorce itself does not override the other parent's parental rights. Trust provisions can create another pitfall. Even if your ex is no longer a beneficiary, they may still end up managing funds for your children if your trust wasn't updated. For example, if you originally named your ex-spouse as trust for your children's inheritance, that role doesn't automatically go away. Without changes, they can still control how and when your child receives those funds. The takeaway is this: divorce doesn't fix your estate plan for you. You'll need to go in and make deliberate updates to ensure your assets go where you want, and your ex doesn't end up with control that you never intended. Even with the best intentions, I see the same mistakes over and over when people go through a divorce and don't revisit their plan. Forgetting to update the beneficiary designations. This is probably the most common mistake. Retirement accounts, life insurance policies, pay on death accounts, they don't follow the plan in your will. They go directly to whomever is listed on the form. If that's your ex-spouse, they still inherit, even years after your divorce, leaving an ex-spouse as a decision maker. I've reviewed many estate plans where an ex-spouse is still listed as an agent under a durable power of attorney or a healthcare directive. Imagine needing medical decisions made on your behalf, and the hospital calls your ex. This is a nightmare scenario that you can avoid with one simple update. Assuming the divorce judgment fixes everything. While a divorce decree settles certain rights and divides property, it will not automatically rewrite your estate planning documents. Your will, your trust, your power of attorney, these will each need their own separate updates. Ignoring future marriage or blended families. A lot of people think, I'll deal with it later if I remarry. But the reality is that blended families cause some of the most complex estate planning issues. If you don't plan ahead, you risk unintentionally disinheriting children from the first marriage, or creating conflict between your new spouse and children. Each of these mistakes can cause confusion, conflict, and even litigation. The good news? With timely updates, they're all preventable. So what should you do to protect yourself and your family during and after divorce? Here are some of the best practices I recommend. Update your powers of attorney and healthcare directives as soon as you're legally allowed. You don't want your ex-spouse making financial or medical decisions if something happens to you. As soon as the law permits, create new documents naming someone that you trust. Consider giving notice to your spouse and revoking your old trust while creating a new will or trust. During the divorce process, you may be able to take some of these steps with proper notice. That way, you're not leaving an old trust in place that no longer reflects your current wishes. Once the divorce is final, create and fund a new trust. This is especially important if you own real estate or significant assets. A new trust allows you to protect your property, avoid probate, and direct assets where you want them to go without leaving your ex-spouse in control. Change your beneficiary designations after the divorce is finalized. Retirement accounts, life insurance accounts, and pay-on-death accounts won't update automatically. You'll need to go to each financial institution or plan administrator to make these changes. Revisit guardianship nominations for minor children. Even though your ex-spouse may still have parental priority, you can still nominate guardians in the event that something happens to both of you. This is especially important in blended families, where you may want to ensure that your child is cared for in a way that aligns with your values. The key is to be proactive. Divorce creates a lot of change, but if you can update your estate plan step by step, you'll protect yourself, your children, and your future. Divorce affects much more than property division. It reshapes your estate plan. This is why it's important to coordinate with both your family law attorney and your estate planning attorney. Together, they can help you understand what changes you can make during the divorce process and make sure that your estate plan is updated and fully aligned once the process is complete. The best time to start is now. The sooner you talk to an estate planning attorney, the better positioned you'll be to protect yourself and your family, both during divorce and long after it's finalized. If you're going through a divorce, or if it's been finalized and you haven't updated your estate plan yet, I invite you to book a consultation with my office. We'll walk you through your documents, the changes you need, and make sure that your estate plan fully reflects your life today.